of individuals which are not necessary. That there are things, the goals to be achieved can be achieved without the imposition of some of the aspects of the bill. Citizens' rights are sacred, and you ought not to interfere with those rights unless there is absolutely no alternative. And we believe that this bill has placed in the hands of individuals authority that ought not to be. In fact, as I'm sure the legal commentator on the panel will address later, the bill does not even give you redress to the courts. So apart from your rights being violated, you have no redress to the courts. In addition, the bill goes so far as to give the people who police the bill immunity. The bill actually allows for the people that no legal action can be taken against anybody who, in the exercise of the authority given to them by this bill, may trample upon the human rights of an individual. It allows the competent authority, in this case the health minister, to do things that are ordinarily done only by a court order. So, for example, the requisitioning of people's property, whether it be motor vehicles or even your private home, and you have absolutely no redress. It speaks to, and I'm sure Dr. King, who is a medical doctor by profession, will deal with that. It gives the minister responsible the authority to make any lab a lab suitable to do tests. Nowhere in the legislation does it use the words certified lab. It simply says any lab which the minister deems to be an appropriate laboratory can in fact do the test. That opens itself to all kinds of madness, that somebody close to the government may just open a lab now and everybody going to decide that you must test everybody. That's millions of dollars. I'm not saying it's going to happen. The fact is the way the act is written allows the minister that authority. Critically, and again, I'm sure Mr. Richelieu will deal with that, critically, it contains a section which allows the minister to create an offense. So if the offense is not yet in the act, the minister has the ability to actually create a new offense and to set penalties. Things that are usually done by the courts, by the parliament, and overseen by the courts. And if you have a problem with a magistrate's decision, you can go to the Court of Appeal, etc. There is no such appeal under this act. And therefore, we need to have great concerns. All of us, each one of us is interested in ensuring that COVID does not overtake St. Lucia. But we believe that we can do that without the imposition and the trampling on one's human rights.
Thank you very much, Mr. Francis. We will invite Mr. Alberton Richelieu at this moment.
Yes, good night, everyone. Funny enough, I had the opportunity, and with much discussion with some of my friends, well, some of my legal friends about it, what I don't want to be misinterpreted at this point is the fact that it appears, or in fact it is, a sort of show put on by the St. Lucia Labour Party to believe at the end of the day that it is a Labour Party platform. My position here is that as a lawyer, I have my role in society and my responsibility to the society at large. Now, one of the fundamental things I've realized has happened over the time is that it is thought that because there is dissension, everybody seems to treat it as some sort of political controversy. But it is important for me to have a quote before I proceed. It is a quote which is taken from a legal luminary, and it was approved by a constitutional court in Jamaica, and it goes thus: dissent has a troubled history. The word descendant has often been a pejorative term. Dissenters have rarely been welcomed and are frequently viewed with suspicion, not only by the dominant power, but also by the majoritarian opinion. And yet in a democracy, dissent is essential. It is indispensable to our freedom. In fact, it is one of the authentic voices of our freedom, particularly in times of exception, example, a pandemic, when the freedom of the citizen is at stake, and particularly when the state itself seeks to curtail fundamental freedoms in the name of national security or whatever other perceived end worth pursuing. Let me make the point very clearly from the beginning that emergency laws are well known from time immemorial. Emergency laws, by its very nature, would inherently intrude and invade on the fundamental rights and freedoms of individuals. But we must remember that we have a constitution. The constitution makes provisions for fundamental rights and freedoms. However, there is always a proviso under all these fundamental rights and freedoms, which says that a law can be passed, or in fact nothing in the law, etc., which is inconsistent with those rights can be affected. And I think it goes on in that particular section 48 or 52 of the Constitution to say, if that law is reasonably required in a democratic society. What that means is there are a number of laws which have been passed. I can give a number of examples. The Land Acquisition Act is one, which of course impinges on the right to property. The Extradition Act is another, which impinges on the right to liberty. But what is important about legislation is that if you are going to do that, you must expect to have consultation across the board so that at the end of the day, where there's likely to be the intrusion, it may not cause that kind of political controversy. In other words, you cannot sacrifice one's fundamental rights and freedoms for expediency. And in fact, in my view, that is exactly what this legislation is all about. What is even worse is that it is an act now, it's no longer a bill, it is an act, so they will have to act on it. Now, when I looked at this act from the beginning, I thought to myself, I was trying to figure out in my mind, where did this act originate from? I'm looking at the act all around and I'm trying to find out. But it appears to me that this act was just a draft bill taken up from somewhere on a shelf and just pulled down and said, well, let me just do this and that. What is fundamental about acts which actually intrude on the fundamental rights and freedoms of persons is that you must always have the necessary safeguards in order to ensure that when you're looking at whatever aim and objective you're trying to attain, it is done in such a way that despite it may have infringed the rights, that no one can complain, and that no one can in fact come before or go before a court and challenge it successfully. What we have here is an act which, in my view, and as Mr. Francis was pointing out earlier on, the section which speaks about regulations may be made to allow the minister to create offenses. The important thing about criminal offenses is that, and that is the area of the law in which more constitutional challenges have been raised by anything else in relation to criminal offenses. Criminal offenses are a particular species. It's a species where the liberty of the subject is at stake. And so therefore, you cannot allow a minister who's merely an administrative functionary to be able to create offenses. That in itself violates what is called the separation of powers doctrine. Separation of powers doctrine meaning you have the courts, you have the parliament, and you have the executive. You are now giving the executive the authority which in effect reposes in the legislature. You look at, and the funny thing about that act, I do not know if I could say that it is back to front, but when I looked at section 3 of that act, the definition section, in fact, the section 3, that act, funny enough, is subject to all other acts. And so therefore one asks themselves, what is the purpose of it? It is subject, if I can find the act there now, if we go to section 3, and I was wondering in my mind, is it section 3? Yes, non-application. Where this act conflicts with the Public Health Act, Chapter 1101, the Quarantine Act 1116, or other enactments, or the exercise of a power conferred by or under this act is inconsistent with the exercise of a power conferred by or under the Public Health Act, Chapter 1101, Quarantine Act 1116, or other enactments. This act shall not apply insofar as it conflicts, and a power conferred under this act shall not be exercised so as to limit or restrict the exercise of the power under the Public Health Act 1101, Quarantine Act Cap 1116, or other enactment. So there we have an act which we're saying, well, I mean, everybody, and I do not think anybody who's being sufficiently genuine would say that the government should not try to pass legislation in order to fight the pandemic. I mean, this pandemic gets people sick. I mean, right now we have a problem with community spreading. We would welcome an act that would be able to assist us in fighting that pandemic. But it has to be done properly. The other aspect of that act is the vagueness. A lot of different sections in this act, for instance, when it comes to questions of applying for, how they call it, the COVID-19 certificate, there is nothing in the act to indicate what are the prerequisites. At the end of the day, the revocation of that very same act turns around, I think it's at 34 or thereabout, revocation of COVID-19 Act. And it is amazing, you know, the language which is used. If they are going to revoke the COVID-19 compliance certificate, a notice under subsection 2 must state within 21 days the holder of the COVID-19 compliance certificate may make representations in writing to the ministry responsible for tourism why the certificate should not be revoked, and the ministry responsible for tourism shall not determine the matter without considering the representations. I have never heard craziness like that. We have a constitutional right to due process of law. So when the very same person to whom you are making the application is the same person who you have to make the representations to, and one asks the question, and the question is begged: where are the principles of natural justice? Are they being adjudged in their own cause? And for instance, let me give an example of what I'm trying to point out. And there is another, Mr. Francis pointed it out as well, the question of requisitioning of property, which is an official order to virtually take over your property. And I heard a particular, supposedly, in fact, I heard the Attorney General saying, oh, well, you know, when you look at the back of the section, it is the question of prompt payment of so on and so forth. That in itself baffles me, because one would have thought that the necessary safeguard in that regard, and I was looking at the Coronavirus Response Act from South Australia, in which in circumstances like that, judicial commissioners, I'm not saying that the same should be done here, but I'm just giving an example. Judicial commissioners are in fact appointed where there's been a requisition of property, etc., etc., etc. It appears to me that they are trying to parallel the COVID-19 Act with, say, the Land Acquisition Act, where you're talking about but if you look at the Land Acquisition Act, there's a particular quasi-tribunal set up in that regard when it comes to the question of payment, prompt payment. That does not exist in that act. So the question you have to ask yourself, where are the safeguards in that act? And I'm making those comments, not criticizing any government. I'm not criticizing anyone. The act on its face is so vague, particularly an act which invades and intrudes the fundamental rights of persons, that even in that act, you do not even have the opportunity of being heard when decisions are being taken. And one asks the question, if there was proper consultation, wouldn't have been some of those recommendations which would have been made? So it is fundamentally important. In fact, I got the opportunity of going to South Africa to get a case in which it says, South Africa, during a pandemic, government should never lose sight of basic human rights. In fact, it should prioritize their realizations and protection of human rights in such a time even more so. In my view, the Bill of Rights has not been given effect to. A pro-human rights lockdown would have perhaps looked much different. So in other words, even in a pandemic, you have to prioritize the fundamental rights and freedoms. And you do that not by people shouting out that you have fundamental rights and freedoms, because we all know that the fundamental rights and freedoms under the Constitution are not absolute rights. They are subject to certain limitations. Now, there's another section in that act which has troubled me. It is the section dealing with the suspension of liquor licenses. And I ask myself the question, were the framers of that act considering the principles and the issues of natural justice? In other words, when that section, it states, if I can get it here, I think it's 15. Yes, 15. The minister may by order published in the Gazette suspend a liquor license for the sale in St. Lucia of intoxicating liquor under the Liquor License Act, Chapter 1317. Now you ask yourself a question. How is a liquor license obtained? A liquor license is obtained by a special sitting of a magistrate's court along with other persons, and at the end of the day you have a judicial determination. The question I ask myself, is it that I'm understanding that the minister has the right, or in fact make an order for the suspension of a liquor license which has been the subject matter of a judicial determination, and then comes and tells me that you're suspending somebody in a notice in the Gazette? It has nothing to do with, have you given that person an opportunity to make representation and be heard as to causes and to show cause why the liquor license ought not to be suspended? If I may, I do not want to take up most of the time unless, of course, I'm called upon to. But there are so many shortcomings in that act. It is so vague. And Mr. Francis would be able to assist me on that in just as recent as sometime in August 2020 or so, a Trinidadian court made pronouncement on vague and imprecise provisions in an act. That in itself, on the face of it alone, could very well not be able to pass constitutional muster. So therefore, at the end of the day, it's not what you do, but how you do it. There's a need, in my view, before that act was passed, there was need for, like I say, some people may look at dissension as trying to reap political controversy. Oh, this one is Labour. By the time it comes to me, say that I am Labour, I'm UWP. That has nothing to do with it.
Mr. Richelo, you have 2 more minutes, and we'll come back to you in the second round.
And so, at the end of the day, my position is that this act ought to be revisited. Serious considerations of fundamental human rights and freedoms be taken into account, and of course, on the table, and look for proper consultation in order that, at least we can have something to at least battle the COVID-19 pandemic that is facing us. Thank you.
Thank you very much, Mr. Richelo. At this time, we invite Mr. Casimir to say a few words, and then we will come back to you after Mr. Casimir. Mr. Casimir, we'll ask you to kindly unmute your mic. Thank you.
Apologies, just to remind individuals that this discussion is really an opportunity for us to really unpack the COVID-19 bill, as you've seen so eloquently done by our two individuals so far, Mr. Francis and Mr. Richelo. And I just want to remind individuals that when we are dealing with the legal fraternity, as Mr. Richelo just explained, it's very important to dot your I's and cross your T's, especially when you're dealing with a government that individuals continue to ask questions about in terms of transparency. And so we want our listeners and individuals paying attention to really understand why it is that our participants are picking out aspects of this bill to let people know that this thing needed consultation and that individuals needed to do what was needed. And I would just draw a reference to what happens when I's are not crossed and T's are not, I's are not dotted and T's are not crossed. We see a situation where the law speaks to a deputy speaker when it's convenient. And of course, once you do not have, that sort of approach where everything is done, and we keep speaking of the spirit of the law, we have to go back and really look at everything through this bill and ensure that we do not take any chances. And so this is why it is very, very important. Even reporting on CIP, we see that if things are not done in a manner that every single aspect is put in a way that is irrefutable, then we really have causes for concern. I just want to say quickly that there are certain aspects of the law that I as a young individual have read that I continue to ask questions about, and I continue to wonder if persons are really paying attention to what is going on in St. Lucia. And Mr. Richelo spoke about the power to requisition the building. And for me, reading this aspect of the law, what it speaks to, where the minister, after consultation with the chief medical officer, is satisfied that it is reasonably required for statutory purpose to requisition a building vessel, and that's 11.1. Then it goes to 2, where the minister requisitions a building vessel, aircraft, or article under subsection 1. The minister may take possession of a building. And for me, this is extremely scary, especially when you read, like he said, some of the notes at the end, which speaks to whether payments would be made and that sort of thing. It is extremely vague, simply because, again, we are in an election year. Again, we are dealing with a government that a lot of people do not trust. When a building is requisitioned, what are we talking about? Is there a rental fee? What happens at the end? If there is a rental fee, how much is it? And I ask the question, if at the end of the day we believe in transparency, why don't we, through this bill, why don't we, through an attachment, at least right now make a conscious effort to ensure that if we need certain aspects or certain buildings, that we identify those buildings right now or even before the bill was drafted, so that we could know engrossly this building would be the building that would be identified in library, this building, the same way we've identified respiratory hospitals. I think in the interest of transparency, we need to just identify where those buildings and who those buildings are, and that will ensure that we have discussion. Again, individuals in the community are asking whether or not this is put in there so as to give friends and loyalists some sort of financing, because again, it is unclear whether or not a certain amount is going to be paid and what that amount is going to be paid for a requisition in those buildings, or if it's going to be done for free. And so you have to ask whether or not in an election year, there is some electioneering there for kickbacks, and you have to ask yourself what is going on. And I'll just hasten to say before we go to our next speaker, again, concerned about some of what's going on in our bus sector, because the bill also speaks about wearing of mask and physical distancing. Under 21(1)A says, wear a mask or suitable covering over his or her nose, mouth when in public. And they spoke about this is extremely vague again, because we have individuals who have pre-existing conditions and they are legally obligated at all times to wear a mask. And I mean, again, when you're dealing with a government that may just go back to a law or an act, as they say, an act on it, you never know when somebody who's conniving would see an individual who may have a pre-existing condition, especially, let's just say, for instance, a bus driver. The bus driver is under this law required to wear this mask for the entire period. It does not specify whether or not somebody is exempted because of a pre-existing condition. And again, as Mr. Richelieu so eloquently said, the recourse is unclear. As he said, we spoke to a little bit about whether or not, those certificates would have been, who gets those certificates. And we've seen that this law seems to speak to a tourism sector for certificates. And of course, tourism generally speaks to persons coming in, but there are persons who use or require those certificates for local activities. And again, we must ask, what is the standard for receiving those certificates? I still get notifications from individuals who've been waiting for a certificate over a month. What is the time period for receiving those certificates? And so there's a lot to unpack tonight. And of course, I will just continue to just move on. And so we have some discussion on, of course, laboratories. And we know that we currently have a laboratory which is not necessarily commissioned as yet. And we've seen under the bill, the designation is given to two individuals, pretty much. Designative power to designate a laboratory is given to two individuals. And so we will now go over to Dr. King to get his input on this bill, his position on the various facets of this bill.
Thank you. Good evening, everybody. I think I want to start at another level. To me, I am fundamentally concerned with democracy in our country. And it would appear to me that our democracy is a thin veil or a thin veneer. And it is really dependent, given the way our political system and our governance systems and our constitution and our laws interface, that democracy is really in the hands of the prime minister and the elected members, and essentially their ethical commitment to ensuring that democracy is maintained. It's interesting because the Prime Minister recently challenged the media that it should be more ethical in its processes. And similarly, I think the government also needs to look at its ethics. And I did have a conversation with him on this matter when he breached the National Trust Agreement on the prison matter, pointing out that ethics is actually the higher order that we must aspire to, especially as leaders. So for me, this COVID-19 bill is just showing you yet again our flawed system that continues to allow democracy to be undermined. It first hit me very hard like a slap. I think it was on January 5th, 2012. The President, Claudius Francis, will remember, we were debating the Constituency Council bill. And it was a flawed piece of legislation. I think everybody agreed with that. But it had to pass for expediency based on the upcoming budget. That was my understanding. Claudius will always correct me. And that bill passed. It was said at the time that possibly we would review it in 3 years' time. The problem is we never did. That bill still sits, or still stands, I should say. And we lost an opportunity, in my view, to have a process of consultation and discussion of local government and the role of constituency councils in local government, which would have been a fundamental step forward in democracy if we could have come up with a much better bill. But my president at that time told me, don't worry, it'll pass, because you see, I mustn't worry, I must still say what I have to say. Because in the Senate, there are 5 sitting senators, 3 opposition, 2 independents, and there are 5 government senators, and the president has the casting vote. The president is always appointed by the government. So you understand the Senate always passes once you have all members. Now, the anomaly in the Senate this time around was rather interesting, because we were down 2 opposition senators and down 1 government senator, and 2 independent senators were sick. So there was no quorum, because the standing orders of the Senate are quite clear. You must have 6 sitting senators and the presiding officer, namely the president. So there was no quorum for this bill to pass. And what then transpired, I suspect, will be the subject of legal challenge, because the government then appointed 2 temporary senators to allow the business of government to go ahead. Now, in my view, the government had other options. And I find it interesting they chose that particular option. The government had the option of extending the state of emergency. And that, as far as I'm aware, could be done even by the Governor General in a very expeditious manner for a matter of 7 days, I think, or 21. I think the Constitution defines that. The other thing that could have happened is, and I think it would have been a better system, is what Grenada did, which is that you attach these COVID-19 sections should really have been regulations under the Public Health Act and the Quarantine Act. Those main acts, which are standing pieces of legislation, give authority and power with the necessary safeguards that have stood the test of time. And I think it would have been much wiser. We would have achieved the very same goal of managing the COVID-19 safely, but we'd have done it in the safer environment of existing legislation, namely the Public Health and Quarantine Acts. And Mr. Richelieu was very clear on even the point that this act is still subject to those 2 acts. So why wasn't it just a set of regulations? I think that the weak accountability in our system is interesting. And I remember not only in the Senate talking about the Constitution Council bill, but the anti-gang bill and the CIP bill. And this habit or this precedent of passing all bills in one sitting, invoking the standing orders to do away with first, second, and third readings on separate occasions, and let us just have all in one sitting. That is a dangerous precedent that should never have been allowed to continue and should have stopped. We should always just do a first reading and then allow the bill to be properly debated. I was very happy to see Adrian Auger, Senator Auger, Dr. Auger talking on the bill, on his views on it, on choice, and further the Attorney General expressing his views. In fact, I think all pieces of legislation, especially controversial ones, should have that kind of public hearing. When it comes to voting in the Senate, very interesting. And I remember, you see, we often get in a conundrum. Just on a lighter note, I believe that you either vote yay or nay, aye or no, on everything. However, there was one time I abstained, and Claudius Francis insists on rubbing my nose in it, but I had a very clear reason for abstaining in a particular vote. That was on the guarantee for the loan from CDB for the UWI infrastructure works in St. Lucia. Claudius Francis told me, you are a big advocate for education, and yet you abstain on this bill. The reason I abstained on that bill was because of the hubris and the arrogance of the leader of government business at that time, who, when I asked him for information on the technical information that CDB had done, he told me, I don't need it, I must just trust the technical officers. Well, you see, as a parliamentarian, I don't trust technical office. It's not my job to trust. It is my job as an independent senator to stand up for civil society without political tribalism and speak for what I think is in the best interest of the people. And I wanted to know what exactly we were borrowing for what, or how much we were borrowing, or we were guaranteeing for what reason, so I could make my own judgment. I am not a fool, I don't think. At least not most of the time, I'm not a fool. And I think I can read and I think I can understand. So I wanted that opportunity. He told me I could not get it. I could not have it. So I said, I cannot then vote. Yes or no? How can I vote yes or no when I don't know? So I abstained. Still suffering from that with Claudius Francis, by the way. But you know, some other big issues that are coming through here. COVID-19, the pandemic, has created panic and fear. And everybody is capitalizing. Now the media, the global media has done this, and our local media has participated. And what has happened, the media sensationalizes fear because that sells and that attracts. However, it does put us in a very difficult situation as people making decisions, because human beings make decisions very often on emotional basis. And when you put fear in us, we will tend to be blinded by that and make decisions that we otherwise would never make. One of them is to trample on our constitution, or agree with the trampling on our constitution, agree with dispensing of human rights, because we are afraid for our very lives, because that is what the media has perpetrated on us. That, I think, is wrong. Now, of course, politicians capitalize on that for their own reasons. President Trump is on one end of it, and our prime minister is on the other end of it, capitalizing on the fear to do what they would like to do for whatever reason. Now, ostensibly, it is to protect us, but we need, as thinking people, we need to question that at all times, because government needs to be held accountable, and we must, and that is a role of civil society. In this political tribal environment, which is getting worse, the reds and the yellows will line up behind their leaders, red and yellow. Civil society is the buffer between these two tribes. And what we are supposed to be doing in civil society is trying to bring that moderate voice to the discussion. Try to bring that independent voice. That's what the independent senators do. That is what those of us in civil society seek to do. Clearly, we are not always right. But it is wrong when you malign civil society because we dissent with you on a particular issue that you have, or something you are trying to do, such as COVID-19 bill passage, and we don't agree. We want to have further consultation, but then you malign us. The Bar, Hotel and Tourism Association, Medical and Dental Association wrote to say we need more time on this, and the government could have given that time safely while protecting people, but the government chose not to. That, I think, is the fundamental error in my view, and the fundamental thing that as St. Lucians we must push back against, because is this just the beginning of more to come? That's the question we have to ask ourselves. A stitch in time saves nine, says my primary school proverb. So we need to stitch in time, because if we have a totally torn democracy and a totally torn garment, maybe we'll not be able to stitch it back. And a government that is seeking to have more centralized power is seeking to be more totalitarian, more dictatorial. And by the way, as the musician Prince says, the two-party system is a thin veil over fascism. Now, you see, so the fascism is just one step behind. So, St. Lucians, be very careful. Let us put brakes on the erosion of our democracy and our rights. When you look, and when I talk about command and control, if you look at the Public Health Act in contrast to COVID-19, because I asked myself, why would government not put the COVID-19 bill sections as regulations under the Public Health and Quarantine Act? So I said, is it central control? Because the government seems to be keen to have more central control for more expediency, ostensibly to do the right thing. Mind you, we need the checks and balances on that. So you see, the current act, I believe, it said essentially The members of that command center, as it is called, are really government people, permanent secretaries and ministers, and there's a minister of cabinet that chairs it, and the CMO is the deputy chair. The rest of them are all permanent secretaries. I think I have the act here. I can tell you exactly who it is. Yes, the command center, a minister of cabinet as chairperson, chief medical officer as deputy chair, a representative from the office of the prime minister, the permanent secretary of the ministry responsible for tourism, the permanent secretary of the ministry responsible for health, the permanent secretary of the ministry responsible for finance, the commissioner of police or his or her designate, a representative from the National Emergency Management Organization, a representative from the St. Lucia Tourism Authority, the principal information officer of the Government Information Service or his or her designate. Now, the Public Health Board, which is the board that is supposed to govern the Public Health Act, is interesting because in Section 5 of that act, it says the minister shall. Now, Mr. Richard will advise me on that. The minister shall establish a board. My understanding is shall says it's a command. It's not a may, it's a shall. So the Public Health Board should be in existence right now. I'm not sure if it is or it isn't, but it should be. So the minister shall establish a board to be called the Public Health Board, and that board will comprise persons who, in the opinion of the minister, representative of some aspect of public health. And without limiting the foregoing, such persons may include representatives of commerce, labor, agriculture, social and cultural organizations, the medical profession, and local authorities. Now, this board is chaired by the chief medical officer, and this board is the one that would govern the oversight of the implementation of the COVID-19 sections. And I do believe that is a more democratic and a better body. It's a more technically competent body. It's a better body to direct and, for that matter, advise the Minister of Health. The Public Health Act and the Quarantine Act are very powerful acts as they currently exist. Make no mistake, they are not weak. They are very strong. But they are contextualized into health emergencies, and they're contextualized to be confined and to confine certain powers so that the minister and the CMO cannot overstep the power. So that, I think, is what I would like to see. And the questions that we as citizens need to ask the government is, why were the existing acts not used? Are they constraining in some way? What is the government plan that the Public Health Act and the Quarantine Act constrain them from doing, and they therefore need this COVID-19 special bill? Further to that, when we're going to have more viruses like this one as time goes by, as next year comes and the years after, are we now going to have a COVID-21 and a COVID-22 and a COVID-23 or an Influenza 25 act? What precedents are we setting here when we move away from our existing pieces of legislation which have governed all that we do? And I must tell you that those acts, the Public Health and the Quarantine Act, actually are far better, more nuanced in terms of how they control what medical health information, what is a notifiable disease, how you're supposed to notify, how you're supposed to inform, what is surveillance, what is isolation, how can you do surveillance, how can you not, etc., etc. So St. Lucians,
you have
I
1
think,
minute.
Thank you, because I'm just finished. In fact, my plea to St. Lucians is actually, let us guard our democracy very jealously. Dissent and dissent and dissent in a civil manner. The problem with what is happening, with increased tribalism, with increased frustration and pressures in our country, civility is also at risk. And when you malign civil society and you silence civil society, you actually are silent, you actually are giving a blow to civility. This is a big error by the government, and they should retrace this. They should pull back, wind back on this. We will support the government doing the right thing as civil society. We definitely will. But we will not support the government if it's going to do the wrong thing. Thank you.
Thank you very much, Dr. King. Very, very interesting discussion so far. At this point, we will invite Senator Karine James from Grenada. Senator, We are very curious to learn what happened over in Grenada. If you can share with our viewers home in St. Lucia, because we know in Grenada that the bill was initially introduced, and because of the advocacy over there, it was removed from the table. Please go ahead. And after which, I will go back to the panelists and invite anyone to add and to anything that our colleagues had to say. Please go ahead, Senator.
Thank you so much again, Senator Lucia, and to the listening public. Good evening. Thank you for having me. It's a pleasure. As I've sat here listening to the introductory speeches of the other panelists, I come to the realization that Grenada's COVID-19 control bill and the St. Lucia Prevention and Control Bill, they share similar characteristics, which challenges or rather contradicts the constitution of the land. Particularly so for the fundamental rights and freedom section of our citizens. However, the difference, as you would have mentioned, is that ours was not tabled. Ultimately, our bill was to regulate the containment of the spread of the coronavirus in the state of Grenada. And this bill was a matter of great concern from the time it got into the public's eyes and through social media platforms like Facebook and WhatsApp. Persons were privy to what the content of this bill was. And as a result of that, many stakeholders and citizens alike of the country, they were totally opposed of this piece of emergency power legislation. They viewed it as almost a martial law type of ruling. And one of the fundamental aspects that I must mention as a young person myself, I am very, very, very proud of the fact that the charge towards forcing the government to retract such a piece of legislation was first and almost entirely led by young people, free from any direct political affiliation, just young people who have a conscious mind coming together, protesting for their voices to be heard because they felt as though they were directly impacted by this bill, and for them to remind the government that the people is in charge of the country. It is also important to note, as I would have mentioned, how influential social media platforms were towards bringing awareness and facilitating that sort of informal setting for a forum discussion on the bill. Because previously, before it got into the public domain via social media, there was no public consultation. And so here you have a bill that would affect person's life, going to be tabled into the two houses to be passed, and there's no consultation. And to me, that baffles me a lot. And to me, seeing young people take that lead and just do it without any, like I said, without any affiliation with any political party, I think what they did was to show how impactful the voice of young people or the voice of the youth is. It shows that if given the opportunity to be a part of the decision-making process properly, how our voices can be a mainstay of political discord. It also shows to me that that is the kind of energy, the kind of passion, the kind of drive we need at this dire time to safeguard our democracy. And that is one of the key terminologies that I've pulled out in each presenter's speech. We have to safeguard our democracy. And I believe that if more young persons in St. Lucia, they get more affiliated, they get more involved in terms of how acts become law, how the whole system of how the place is governed. If they get more educational opportunities to explore, I think that a great job will be done. And these kind of bills that almost look as if it's draconian, it would not be something to discuss here tonight. So I am interested, and I am looking forward and continuing to throw in St. Lucia to see how this whole situation evolves and to see if the government will really take heed.
Thank you so very much, Senator Karine. That was very interesting. We made a few notes, and we're seeing the chat room is buzzing with questions already. Mr. Claudius Francis, I know you gave a brief introduction, but now we invite you to the floor. We ask that you please unmute your mic.
Right. First of all, let me just add to something that Senator James said. In Grenada, there is no opposition party in the House. Okay? So Prime Minister Mitchell faced absolutely no opposition if he had brought the bill to the parliament. Consultation. Because the Bar Association, following the lead of the young people, led the charge, right? The bill was removed, even though there was no opposition in the House. In St. Lucia, we have 6 members of an opposition. The Bar Association wrote in objection. The St. Lucia Hotel and Tourism Association, which industry perhaps is the most affected by the bill, wrote in opposition for consultation. The Medical and Dental Association, the Chamber of Commerce, yet the government was adamant it would not accede to public comment. The government said there was an urgent need. Well, let's recap. The House of Assembly was actually set to meet the second Tuesday in September, with the state of emergency due to expire on the 30th of September. On the instructions of the government, the sitting was adjourned to the following Tuesday. Further, on the instructions of the government, it was further adjourned to the final Tuesday of September, in effect, a day before the expiration of the state of emergency. Is that a government which talks about expediting the matter and it was necessary because of emergency? If there was an emergency because the state of emergency was about to expire, it was because the government sought adjournments to the House or postponements on 2 occasions. But let's look at this. Even then, if the government's agenda had been pursued, it would have meant that the Senate, even by the government's own schedule, the Senate would have met following the expiration of the state of emergency. How then can the government claim it was trying to expedite because we were in a state? It was the government scheduling itself that put the reading of the bill after the state of emergency. Then on that day, there was an interview between the Star newspaper and the Attorney General. And in that interview, he said he would like to see the bill become an act next week, Tuesday, because the Monday was a holiday. In effect, by the government's own agenda, we would have had a full week without a state of emergency and without a bill. Yet the government's position now is that they had to pass it, they had to breach the law because of emergency. I just want to raise 2 sections before I go into what Stephen said, what Stephen raised about the Senate. Alberton spoke about the vagueness of the bill, and he's right. In the case, Dominic Suraj, Marlon Hines, Christopher Wilson, Bruce Bowen, and Colin Ramjohn, and the Attorney General of Trinidad and Tobago, certain sections of their bill, which are similar to ours, were deemed unconstitutional. Another interesting part about Grenada, which I forgot, the Attorney General in Grenada is a former judge in St. Lucia, Ramdeen, he's a judge, and he even came out and apologized, saying that it was never the intention of the government to have imposed draconian measures on the people, not in St. Lucia. Then you look at section 19 of the Act. It says the chief medical officer may require a person to develop a COVID-19 plan. There is no definition in the Act of who a person is. And how does an individual person develop a COVID plan? What does that mean? That the person has to develop a COVID plan. Stephen spoke about the composition of the command center. Not a single member of civil society. Only government people, including the GIS. But no member of the opposition. no member of the Bar Association. In fact, there is not even a lawyer. And one does not say that lawyers must be in everything. But you would think a command center, which is going to oversee day-to-day operations, would be guided by a legally trained person, no lawyer. But there are about 5 government people, including PSs. So where does that go? Then you have the situation of, as I said earlier, there is no right of appeal against any situation, any judgment that is taken by Senator Mary Isaac. Our Constitution specifically forbids a non-elected member from being a Minister of Finance. And one of the reasons for that is because it goes back to the old legal maxim of no representation, no taxation without representation. And that is why a senator ought not to be a finance minister. But this bill gives the senator, Mary Isaac, the ability to tax and to decide who should pay and who should not pay. The very thing that the Constitution is seeking to forbid. Then you also have the section which says, I'm looking for it, it's a section which says all regulations. Right. Section 20, Alberton, which I know you have your bill there. Look at section 20, subsection 4. It says a protocol a protocol which was issued prior to the commencement of this act is deemed to be issued under this act. Well, let's go back to see the protocols which were issued under the state of emergency. All of the regulations, all of the SIs passed under the state of emergency begin with the preamble, by virtue of the powers afforded me under the Emergency Powers Act, Section 3, I make the following orders. But what does Section 3 of the Emergency Powers Act says? It says any order made under this act shall be subject to affirmative action and affirmative resolution in the Senate and in the House. What that means, panelists and listeners, is that every single SI that was passed under the state of which is mandated by the very act under which the Prime Minister, as he was called under that act, the competent authority, issued. None. It means, Stephen, every person who was arrested under the regulations now has a defense that they were arrested under an improper law. And there's precedence for that. Alberton is a lawyer. Remember when several people were arrested by the, we used to refer to them as the police Zodi. It turns out even though courts had convicted some people, when a case came by a particular lawyer who was a lot more alert than his colleagues, he said, but none of these police officers were ever sworn in as constables by the Commissioner of Police and therefore had no powers of arrest pursuant to their employment. Yes, they can make citizens arrests, but they were making arrests pursuant to their employment. Now, that's the danger. People had already been fined and sent to prison, only to find out that the law, even though it was passed properly, the police who were policing the law were never proper police officers. There was another one where the proceeds of, I can't remember what it was, where you have money you can't account for. There was an individual now deceased. The police arrested him for having in his possession $1.3 million, which he could not account for. They seized that. He went to court. I happened to have been in court that day, as I usually am watching the cases. He had no lawyer when he reached there. The lawyer, when he got there, a lawyer came on and says, what are you here for? And he told the lawyer. And the lawyer said to him, I'll represent you. You'll be out of here in 5 minutes. Even though you're just coming here to plead, we will insist we are ready for the case to go on. $300,000. That's my fee. And the man is trying to figure out, how is it this lawyer is going to get him out? But he's going to lose $1.3 million. If the lawyer can get back $1 million for him and he take the 300,000, he's good at that. He said, proceed. The lawyer stood up and said, in those days, they called the magistrate, Your Worship, said, Your Worship, go to the section of the law, read the preamble. It says this act shall come into effect by proclamation, never proclaimed. These are the dangers that we face, going back to Alberton's comments about dissidents. If you don't have civil society monitoring those things, here was a man who could have lost $1.3 million on an act that was never proclaimed. So he just walked out of his money. So these are the things we're talking about. And finally, Alberton, I just want to say that to you. In the case we spoke about, going to section 65 of this COVID bill, which gives the minister the power to create offenses. This is what Justice Ronnie Budi Singh said on exactly the same point in Trinidad and Tobago. He said at paragraph 131, Roman numeral 2, it is declared that this section of the Act is unlawful as it gives the minister the authority to create offenses. Unlawful, unconstitutional. Yet we pass that here. And nobody is doing anything because the Attorney General, the Prime Minister, and his government have nothing to see. And it was interesting, even debate in the House, not the minister spoken on the bill. That's how uniform they were in the uninformed view. So that's my comments on this.
Thank you, Mr. Francis. Very detailed, very interesting discussion. I want to remind our viewers who are watching us on UTV channel 124 that if you have any questions, you can always tune into Facebook at Bebe4Grozile. That's the number 4, Bebe4Grozile. There's a live chat, a live session going on Facebook right now, and you can ask your questions there. We invite Mr. Alberton, if you have any comments you would like to make on what Mr. Francis just said. We
Yes,
have to unmute your mic. Great. Go ahead.
As a matter of fact, it reinforces the point because Mr. Francis made the point. And if you look at section 17, subsection 4, in relation to physical distancing and that sort of thing, you see that the minister may, on the recommendation of the, or the published in the Gazette, issue guidelines on physical distancing and quarantine. The very same case that Mr. Francis just made reference to is that because of, by virtue of section 60-something, which speaks about the creation of offenses, the question is, if there are a breach of the guidelines, what happens?
Exactly.
And you know what the judge said there? It is declared that the relevant public health 2019 novel coronavirus 2019 COVID regulations are unlawful to the extent only that they make a breach of the guidelines for places of worship made by the Ministry of Health a criminal offense. And that is why that I listened to Mr. Francis very carefully, and it just reminded me, and there is the senator from Grenada, that my mentor in administrative law was Dr. Francis Alexis. He lectured me quite a while. And one of the cases, as Mr. Francis was pointing out, is a case from Barbados. It is the case of Briggs. They were trying to extradite Briggs back to either some country or the other from Barbados. And one of the orders that they made, it said, was subject to negative resolution. That particular order never passed muster of a negative resolution by Parliament. And at the end of the day, Briggs had to go on his own. He could not have been extradited anywhere else because there was nothing whatsoever in law. So Mr. Francis is quite correct when he speaks to most of these SIs will not be able to see the light of day. And if I may just point out, for example, and you see, I think that our leaders are not considering the significance of our fundamental rights and freedoms. I just had the opportunity of reading a New Zealand case in which almost provisions of that sort in St. Lucia was struck down by the High Court of New Zealand in a case called Christiansen and Director of General Health 2020. And in there, they seem to be saying, and that is what we want to avoid here, you know. The act has already been passed. That is what we want to avoid here. People do not want to run into a controversy to say, oh, well, you know, you heard them fellas talk about that, so they want to revoke the act. No, it isn't anything like that. As Dr. King was pointing out, it is an example to a lot of our leaders, most probably consultation. And that is why I never went into detail in relation to the strength of the Public Health Act and the Quarantine Act. But that is why I pointed out the kind of tautology which exists, the contradiction in terms which exists. When you have an act as powerful as the Public Health Act, as powerful as the Quarantine Act, you create another act and you say that that act is subject to those acts. It makes no sense at all. And that is why...
Sorry. I just wanted to add a point you made earlier on, and I think Kenson touched on it about the Deputy Speaker and convenience. You read earlier, Alberton, the section relating to requisition of buildings, which is section 11, subsection 3. Listen to the words. After the requisition, the government shall make prompt. Who decides that? What is prompt?
Prompt, exactly.
As a lawyer, I'm sure you daily deal with land acquisition, land taken under the Land Acquisition Act. I am aware of people whose land has been acquired by government for a public purpose who did not receive payment for 15 years.
15? Alone?
15 years. So not simply because it says a prompt,
and
it says adequate compensation. At least in the Land Acquisition Act, the language is more definitive. It speaks to, in effect, the land or the property being surveyed and the market value. There is no such definition in this one, Stephen. I see you shaking your head. It just says prompt and adequate. What does adequate mean? As I said, at least in the Land Acquisition Act that I have read, there is a formula by which the value is arrived at. There is no formula in this one.
Exactly.
So I just wanted to make those 2 points.
Exactly.
Thank you very much. Mr. King, would you like to add anything to the discussion at this point?
No, actually, no. I think it's very interesting to hear Mr. Francis and Mr. Richlow look at the points of law. You know, I mean, I am by no means am I a legal mind. But one of the things about a lot of people look at me because I'm a laboratorian and they said, do you object to the COVID-19 laboratory thing? I don't really. I understand what has been said. I don't really object, providing that it's a fair process. So any of us now apply.
How do you decide the fair process?
That's right.
Based on what it says there, it's left entirely to the minister in her own deliberate judgment to say, Alberton's lab is okay, do the test.
That's
I
right.
agree. I understand. And that's the problem. You see, and we often have this debate with various colleagues that about when we speak of governance and politics. And I tell them that too much of our governance is dependent on the integrity and the ethical behavior of the officer or the person in the office. That is always dangerous in my view, once you don't have the proper checks and balances to ensure that the process is fair and properly and it's true accountability and true redress. So there, as I think Mr. Richlow Alberton said it beautifully about how can I go to the same person who has a vested interest in the very thing that I'm talking about and appeal to that very person to give me fair hearing? Why would they do that? So we must make sure that it's a fair process. And I often get shut down because people tell me, well, no, there are good people in office. Yeah, I'm sure there are good people in office, but I would like more assurance than that. You know what I mean? In fact, Claudius, you may remember the leader of government business told me that under the CIP Act, I said, I don't like the CIP Act because the minister can override the board that makes a decision. And I think that's wrong. You put this board in place, it's supposed to be the check and balance, and then the minister overrides the board. And he tells me that's why you have to elect ministers with integrity. That to me was a non-answer. That's not an answer. I can't. That's ridiculous in my view. But anyway, so my problem in St. Lucia is that system of governance. And good governance, the principles of good governance: consensus, transparency, accountability, responsibility, and rule of law. And it is important. When the Prime Minister tells me he follows rule of law, I try to point out to him, but there's consensus, transparency, accountability, responsibility. There are other factors in good governance that must be applied. And it is we that must be the people to hold government to good governance. But we must have the systems that allow us to do that. And this particular act erodes those very systems that would allow us to hold government accountable to good governance practices and procedures. And that is, I think, the real flaw in it. And I worry that this is the behavior, and I would love to see this behavior stop, cease and desist, this behavior, this practice of command and control and eroding the principles of good governance and democracy. That I want to reiterate again and again and again. People, look, I tell my children, it's 400 years that we in this region have been fighting for our freedom. We've been oppressed for 400 years. We must stop. It's not just 4.5 years, it's 400 years, because the systems keep on being abused in an oppressive way on our people. And you see it every day in St. Lucia. Many St. Lucians who I hope are listening on know that much of our marginalized and depressed communities, these are people that are living under a system of oppression and there's little recourse for them. They can hardly afford lawyers. Legal aid is anemic. You know what I mean? Where do they get access to the third arm of the justice system, or a judicial review of a decision that has affected them? You know what I mean? People, we need to really stop and look at ourselves hard in the mirror and see our ugliness, and let us address it somewhat. And I think this COVID-19 bill has brought it to the fore for us. That's my view.
Thank you very much, Doc. And just some comments from the platform. Persons are saying that they believe that St. Lucia's democracy is already bordering along the line of communism, and it is a very scary line to be on. Another person said, yes, accountability is important, and we as a people are not holding our leaders accountable enough. Enough with this chicken and rum politics. We need accountability. Mr. Casimir, any words?
Lisa, may I just ask Stephen a question?
Certainly, go ahead.
Stephen, if you could look at section 57 of the Act.
Okay.
And Alberton, that question is directed as you as a lawyer as well. Section 57 of the Act.
Transfer of health information.
Yes. Not only does it give the state the authority to take your health information, but section 57.2, section 57.1b gives the chief medical officer the authority to transfer your health information to somebody or an institution outside of St. Lucia. Your view as a doctor, and Alberton, your view as a lawyer.
You see, and I think it's dangerous. And again, it speaks to Alberton's point that this, what appears to be hastily drafted, vague act, is so vague here. What health information are they truly talking about here? So, for instance, in the Public Health Act, there are notifiable diseases, and there's a certain set of information that you give to the ministry as part of that notification. It is not all health information. It is information specific to the notification of that disease, okay? Which is to allow the public health authorities to take the necessary action in terms of contact tracing or quarantining or isolation, as the case may be. It does not speak to health information in its broad context. So that is where this is dangerous in my view. Not that I would expect the CMO to abuse this section, but back to what I said. Laws, and we've said this before, Claudius, laws are not just written for the people of today. Laws stay in place for the people of tomorrow. And there's no guarantee that the people tomorrow who will take up this act to act on will have the same ethics and responsibilities and good behavior and integrity of the people today. So that is a problem that I have. We keep on thinking that laws are just now for now. This law is for 2 years. In the first instance. 2 years. That's going to transcend the general election. Who's going to take up this law after the general election? And what are they going to do with it?
So, Dr. King, on the comment of 2 years, we will come back to that. Mr. Alberton, we will come back to your response. We just want to invite Mr. Casimir, who had a few comments to make ahead of our last question.
Yeah, I just wanted to say quickly, just to add to the discussion and unpacking the act, because Mr. Francis said something that was very intriguing, and I truly think that persons in our community, and I would say specifically young people, because I think they are the ones who really need to pay attention to this. And I think our good friend in Grenada pretty much said that they were the ones who took the lead, and that is so commendable. And Claudius made the point that at the end of the day, Senator Isaac seemed to be the one, not seemed to be, is the one given so much authority under this act. And just to put it in perspective, out of 161,883 electors at the last election, Senator Isaac got 2,172 votes. And we've said that we've been having this discussion about democracy. This act allows the Senator Isaac, who was not an elected member. I think I need people to wrap their minds around that. I need young people to wrap their minds around that fact. Allows her to be the most powerful at the whims and fancies of this government. One of the most powerful persons in St. Lucia for the next 2 years. And we see from in terms of composition of a command center, it says a minister. And for the rest of the entire document, it speaks to the minister. I just wanted to make sure that we paid attention to that fact. A minister of cabinet as chairperson. So it pretty much means that any individual from cabinet, and I guess Alberton can give us that clarity, can act as chairperson when it comes to the command center. And for the rest of the document, it speaks to the minister. And of course, in the notes, it speaks to the minister as the Minister of Health. And the Minister of Health, as Mr. Francis pointed out, is not an elected member of cabinet that our country, our island now has through the passing of this bill and this law, this act, has been given all this power. Restriction of access, young people, I want you to take cognizance of that. This individual who did not win now has the power, along with the CMO, to actually say, and I think this is one of the things that was absolutely shocking, that they said that in an effort to prevent, let me make sure I get the correct place, restriction of access to an area, 18.1, the minister may, on the recommendation of the chief medical officer by order publicized in the Gazette, restrict a person from residing, entering, and leaving an area specified in that order if the person is suspected. This individual, who was not even selected, has given so much power that based on suspicion that she and the CMO can make decisions based on who and what and how people move around. And at the end of the day, we even speaking of two persons. The law speaks to these individuals having the desire or having the power, to say that no more than two persons. And I mean, it is just scary when you think of the fact that this has gone on and this has happened. And we as a nation, we've not really, and I guess young people have not screamed bloody murder. And I just wanted to add that to that discussion. And I think we have spoken about democracy being under attack. And I think this is a prime example that somebody who got 2,000, just under 2,000 votes, if I get that in Grosley, I mean, I wouldn't be able to sing a song by a Catholic church, but an individual who got 2,100 votes has been given that amount of power in our country. I think that's scary.
Very interesting point, Mr. Casimir. One that really digs into your mind and helps you understand how this person or this individual has so much power, was not an elected member. But we have a question from the platform which borders along the line of what Mr. Francis, Dr. King, and Alberton were about to go into. This person is asking, are my rights being breached if I'm wearing? Is it a breach of my rights for me to wear this tracking device? I invite any of our counsel, any legal.
I defer to Alberton on that one.
So, Mr. Alberton, you can unmute your mic. Is it a breach of my rights to wear this tracking device?
You see, the argument is not as straightforward as that. As I indicated, one's rights are not absolute under the Constitution, and you can have legislation which can act as a constraint and limits that right. All I am saying, and all I have been saying from before, is that we must, if it is reasonably necessary to achieve a particular end, there'll be no difficulty with that. The problem arises if it goes beyond that. In other words, you have the situation where, for instance, that, okay, you may want to wear the mask, or you may not want to wear the mask. However, you must understand that your constitutional rights are in competition with other person's constitutional rights. Your constitutional rights does not stand alone. So therefore, in relation to the competing rights, there must be an element of reciprocity. And that is what the whole question of these kinds of legislation are all about. So I am not too sure whether what the person is asking is whether they have an absolute right to say, I don't want to wear the mask. I don't know.
No, it wasn't the mask, I think the monitoring device.
Or the tracking device.
Tracking device.
Tracking device.
Yeah.
That is something I'd have to look into. I'll be very honest with you.
I did do some research on it, though, Albert, and I don't see it as a breach of your rights because, as you said, there is an aim that it's about to achieve, and that aim is to ensure you do not go beyond. You have agreed that the state has in place regulations that say you're subject to a 14-day quarantine period, and in that 14-day period, you can transmit the virus. So you are going to infringe on other people's rights if you go out into the public. So the monitoring device is to ensure you remain within the agreed space, which is your house. So I didn't myself find any case that breached that. The problem I have is that I do not know it is correct for the state to make an imposition on you and ask you to pay for it. That is my problem.
Claudius, I was thinking, and I like to put myself in the situation and say, if it was me, what would I think is right and proper? And I would be very happy to wear an electronic device or bio sticker if it allowed me to stay at my home if I was a contact or, for that matter, sick. And the CMO said, yes, you can, providing you put these things on. I would say yes, because it's an option now for me, which makes it more convenient for me because I don't want to go into state quarantine.
But the second part, why should you pay for something the state is imposing on you?
Well, that's another legal question that I don't know the answer of.
In the research I didn't find anywhere where the state had such an authority to, because it's like a magistrate or a judge putting you on bail, and the government wants to now introduce these same tracking devices in St. Lucia, I understand, to allow for less people being on remand at bodily. They want to impose these monitoring devices. Imagine a judge putting you on bail, and the state is saying, we're putting a tracking device on you, but you must pay for it. That is my difficulty.
Yeah, and the question is, are these reusable devices? I don't know if they are or they aren't. But I mean, if they're reusable, why? You take them back.
Yeah, I think somewhere I saw something that suggested they were reusable. Yeah. But I don't know.
Yeah. I don't know the answer to that question, but anyway, it's again, it just brings up the point. There's a lot of consultation that should have gone into this act beforehand, so we had a better act or a better process. I personally would have preferred regulations, but even so, a better set of regulations that we could attach to our public health and quarantine acts. I think that would have been very wise thing of government to do, and we had enough time. I mean, we've had COVID since the end of March. Surely we should have been thinking about this at that time, how we transition out of that state of emergency that we had at that time.
And which, by the way, the opposition leader did say to the Prime Minister, extend the state of emergency by a week, let's have the consultation. That proposal was put to the government.
But you see, I have a difficulty, especially with this. Was this act implemented pursuant to a state of emergency or pursuant to a public health emergency?
Public health.
I believe pursuant to a public health emergency. That's what I think. That's my understanding.
Used as a state of emergency. And our constitution limits the length of a state of emergency to a maximum period of 1 year.
1 year.
This bill is 2 years.
That is correct.
But this act is 2 years.
That act is 2 years. That is the problem that I have.
Yeah. So the act actually, I wouldn't say ultra vires the constitution, but it certainly does for the government what the constitution forbade them from doing, which is to have a state of emergency for 2 years, because all of the regulations inherent in the state of emergency are contained in this act. All of the powers that the Prime Minister had as the competent authority under the state of emergency are now given to Mary Isaac as the minister. Now, all of those powers are given to Mary Isaac. And as Kenson pointed out, in the composition of the command center, in the interpretation section, it says the minister is the Minister for Health. But on the command center, it says a minister. It means the Prime Minister can decide to rotate the prime ministership of the command center at will. Now, how is that possible?
But you know, Claudius, the government is really has not thought this thing out well. Because if they'd done this as regulations, coming back to that, they would stand essentially until they were changed, right? Rather than having to have a special act for 2 years, which is a state of emergency masquerading as something else, as a COVID-19 prevention and control.
Indeed, Stephen, because that is where the government's genuine or the lack of genuine concern comes in, because I saw the Attorney General being interviewed by Lisa, and she asked him, why 2 years? And his answer resided in section 66, the expiry. He says, the minister, subject to section 2, the act expires in 2 years after commencement, and that it could be curtailed by going to Parliament. But if it could be curtailed by going to Parliament to reduce it, why not start at a 3 month and then go to Parliament and extend it based on the circumstances that present themselves in December? Why go to 2 years? I mean, we all know, Steve, Alberton, Senator James, Lucia, we know when government passes legislation, they never reduce the import of that. If the time is 2 years, they will wait for the 2 years. But if you are so genuine and you say your intentions are pure, then go for the 3 months. Return to Parliament. But what they don't want, Stephen, Alberton, and Senator James, is to return to Parliament for any debate on this bill. So if they have it for 2 years, they don't need to talk about that bill in Parliament for the next 2 years. But they may even use the bill to talk about the reason an election cannot be held at a particular time because it's not conducive. I mean, that is not as far-fetched as people think.
Now, that is a very interesting point, Claudius, because we just got this comment where somebody's asking, is it possible for elections to be deferred to the 2 years since this act gives the PM so much power?
Well, the Constitution and the Elections Act are very clear about how elections can be suspended. But certainly the Election Act, Chapter 1, never considered pandemics. Never contemplated pandemics. In fact, it's interesting. In the Public Health Act, in the Quarantine Act, all of the diseases are actually listed.
That's right.
And COVID is not one. And yet the government has not seen it fit to have gone to Parliament to amend the Public Health Act and the Quarantine Act to I think the wording now is the following diseases. Go to Parliament and change that. Remove the following diseases. In fact, they could even use the it just them generis rule by inserting something there and the like. So it would cover, because there will be new diseases, as Stephen said. So what are you going to do? Go back to the Public Health Act each time to add that pandemic? But they have not. So it's even questionable at the moment whether it is lawful to quarantine somebody for COVID, bearing in mind neither the Public Health Act nor the Quarantine Act speaks to COVID as a contagious and infectious disease. I am not a lawyer, I'm just asking the question.
Right, so we're going to go to, Dr. King, you can
respond. No, Senator James wanted to speak.
Yes, she did.
I wanted to make 2 points, but I'll start with the latter. That is a very interesting point, and what I believe that the coronavirus pandemic have allowed us to do is to look at legal reform in a more serious and objective way, because most of the laws that we might have been implementing, it might have just well been unconstitutional. And so I believe it was Barbados and Jamaica that amended their Public Health Act to accommodate the coronavirus pandemic. And that was one of the main recommendations brought to the government to as an alternative to look into us instead of bringing this coronavirus bill. Also, I wanted to make a comment on the tracking device issue. I think that is the only thing within this prevention and control bill that really drawed my attention. We have been declared COVID-free for quite a number of months now. However, recently we had two cases almost related to there is a possibility that there will be a community spread where persons who were quarantined, they got away from the quarantine center and they would have gone on to parties and so forth. So I think that is a good mechanism to enable or to have them have some sort of control over that spread, because our health system is not in a good condition to carry on that burden if there is a large community spread. And I think that the tracking device is a good technological advancement in terms of controlling that. And honestly, I don't really see an issue with them being able to pay for it, because they have to pay for the quarantine center to which they are as well, which is something that the government is opposing for them to do. So I don't see an issue with that at all.
But Senator, if they are going to be monitored, why can't they quarantine at home?
Well, I just think it's sort of for control, more of control, and then we're not too sure who they might allow in their facility, because the tracking device is just to monitor their movement, but not other movements coming to their home. So I think it will give a much more control to have them in an appointed designated area. Yeah. And also I wanted to make a quick remark on the time in which the bill would have been implemented for us. No, that was one of the unconstitutional aspects towards our bill. No, they wanted to pass that bill for 1 year. They used the word permanent, but it wasn't. I think permanent was not the right word to use in our drafting. But they wanted to pass it for 1 year, but our constitution did not allow for that. Our constitution specifically states, I think is Section 17 or 16 in our constitution, it says that it should not go over 6 months. So I just question myself or introspect a little bit on why did they go for so far as to 2 years? And based on your constitution, are there any limitations that might contradict that 2 year mark for you guys?
But the provision in the Constitution, as far as I know, is 1 year.
1 year.
Okay. But ours is 6 months.
But you see, that is the point that we have been making all the time. And the person from the platform who asked the question as to whether that is moving on to communism. Well, I suppose a lot of people just, the epithets are used and they try to use them exchangeably. However, you know what I have come to realize? We are going down a very slippery slope towards authoritarianism,
Yes.
godfatherism, nepotism. And I say that because, you know, when you give people that kind of absolute power, as Stephen was saying, yes, of course you can say it's a man of integrity. But how do we know? And that was one of the issues I raised in relation to, and I was asking a taxi driver, for instance. I said, supposing that party they said that they ain't like you. You can come with how many applications you want, COVID-19 compliance certificates. There is no criteria set out in the act as to what threshold you should meet for that. And they tell you, I'm refusing you. On what basis? What basis are you going to go and look for judicial review in a court? On what basis? And you see, that is my point. These are issues which arose from as far back as 1942. It was adjudicated upon with 7 judges sitting in the House of Lords. Only one dissented on that particular point, indicating that it was likely to give absolute power to functionaries, administrative functionaries. And from 1942, even thereafter, a Chief Justice of Australia endorsed that one dissent. And that one dissent is law today. And we have moved on. So I don't know what and who could have, what could have been entering their minds to have created that act, which is so vague. And I was trying to make the point earlier on, but it slipped me. I was trying to make the point that even in New Zealand, where there's a Bill of Rights Act, it is not entrenched and doubly entrenched provisions as in our constitution. What they have in New Zealand is a Bill of Rights Act. But yet still, the courts in New Zealand are saying that when you have that kind of legislation, they struck down at least 2 provisions in an order in the New Zealand courts. And I'm wondering, are we really moving on? And the only way, are we now trying to reintroduce any element of authoritarianism? What are we really doing? Are we just throwing democracy through the window? And when these things happen, we must be afraid. We must be apprehensive. Because if a Bill of Rights Act, because even in England in itself, that does not have a constitution, they're constrained in the way that they draft the legislation, making it absolutely clear as to what can be done, what cannot be done. Then we have ministers, you appeal to ministers and you make representations to the same minister who gave you the license and granted it to you in the first place, and then they can revoke it. And I mean, sometimes when I think of these things, you know, I am not looking at it from a political perspective at all. I'm looking at it from a legal standpoint. And I'm asking myself, is this a way of sweeping democracy from under the feet of the people? Thank you.
Kieran, you wanted to say something?
No, I was just saying that is a very good point. We have to, as Caribbean people, not only as St. Lucians or Grenadians, we have to transcend that. Oh, because we're not for the government, you attacking them. If you speak out on certain issues, you're attacking them. It goes beyond that. It speaks to nationalism. It speaks to patriotism. All of the things that we would have fought for long before even my time, before I was born. And I just wanted to mention that was a great point that Mr. Alberto said.
Thank you. And you know, one thing I wanted to say about the 2 years, where it's ridiculous as well. SARS-CoV-2, this virus, is going to outlive 2 years. It's going to be with us for many, many more years. And hence the reason why a 2-year COVID-19 prevention and control bill is either going to be reenacted or what's the word? Going to continue in perpetuity, but I think that is wrong. I think we should have gone back to our Public Health Act amendments and made COVID-19, SARS-CoV-2 a notifiable disease and let it follow all, as we have with HIV or any other influenza, any other of the respiratory viruses like influenza, etc. That is what we should be doing. So it makes me wonder and question why. And that question government must answer, because they can do otherwise to achieve the same ends, which is prevention and control of COVID-19. We don't need this COVID-19 bill to do that. We can do it otherwise. So why are you persisting with this?
Indeed, Dr. King. So we have 2 more questions. We're going to take those 2 questions. Then I will invite everyone to make their final comments in 1 minute, and Mr. Casimir will close. So this also speaks to what Claudius was saying earlier, but Dr. King, this question is for you. As most persons know, you're also a medical professional. How do I know that my information will be kept safe? The bill, now Act, was very unclear. Will this information from this tracking device be shared with another country if I travel? I have so many questions on this.
Lisa, I think we were having some difficulties hearing you. Some of us were having some difficulties hearing the question.
Okay.
Can you just do that again quickly?
Can you hear me now?
A little better.
Okay, so this person is asking Dr. King, how do I know that my information will be kept safe from this tracking device? The Bill Now Act was very unclear. Will this information be shared with another country if I travel?
Okay, now the information from the tracking device, the biosticker, is basically your vital statistics: heart rate, respiratory rate, your vital signs, in other words, your temperature and so on. So that is not really what's the word? That's not sensitive information, right? The electronic tracking device is your GPS, where you are. Well, that can be a little bit sensitive, but like we said, that's probably okay too. But I think it's the vagueness of health information in general. Now, I know the counter will be, well, there's a preamble to this, and this is COVID information, COVID-19 information. But is that all it is? Or does that particular section allow for other health information? I think that's the bigger problem. Now, the truth is we have to trust that the chief medical officer and any medical officers who have a oath of protecting confidentiality will do that. But like I said, I would have preferred the less vague and the more safe Public Health Act definition of how information is handled, what type of information is given on a particular disease and how it is handled. I can understand the rationale for needing to share some of the COVID-19 if somebody is traveling and they may have been exposed. I can understand the need for the place where they're traveling to know that we have a possible contact of COVID-19 coming to you. In a way, I can understand that, right? But that is all it should be. It should be very COVID-19 specific information at best. So I'm not sure why we are so vague, and why we didn't just go with the Public Health Act. I don't understand.
I actually want to disagree with you on the matter where you said it is COVID-related information. Because if you go to Section 50, which is Part 6 of the Act, Collection of Health Information, it says you can actually collect information directly from the person. Right? 50, Section 50 of Section 2. And it goes on to say, if it is that you are correct, that the information they are collecting is simply vital signs, why then would the chief medical officer be authorized to transfer something as simple as vital signs to a country other than St. Lucia? So it is clear that they intend to collect much more than simply COVID. And again, it goes back to Alberton's point. We are only speculating because of the vagueness, but clearly based on the wording of Section 50, the information being collected is more than COVID.
You see, and that's my problem. That's the problem, and that's what needs to be clearly defined. And I think Alberton has made that point over and over tonight, and he's absolutely right. This is too vague, and therefore people we are at risk because of the vagueness.
Right.
I just wanted to say quickly, I mean, and reading it again, it says, for the purpose of securing and protecting health, the ministry shall collect health information under this act. The Ministry of Health. I mean, for me, I not only that it is vague, but all throughout there is, the cross between the CMO, the ministry. Is there somebody specifically from the ministry that will be collecting? This is health information we're speaking of. There's no mention of a doctor. It says, and I mean, for the entire document, the ministry was referring to Mary Isaac and the ministry, but it's just not specific at all. That is extremely scary.
It should have said, I think, the chief medical officer, or a medical officer designated by the chief medical officer. Something like that is what it should have said. But it just goes back to the fact that consultation. So it's a poorly drafted piece of legislation that needs amendment, or needs to be revoked and regulations brought in instead.
Indeed, we're seeing a lot of shoulda, woulda, coulda, and clearly there's so much consultation that needed to have happened, and we saw that key stakeholders came out and shared their concerns as they felt they did not have enough time to share their views and advocate on behalf of the persons that they represent. But we will take this final question and invite everyone to make their final comments in 1 minute. And the question that is all over and persons are asking, we've heard everything that you've had to say, can this act be repealed?
Well, any act can be repealed by the government simply returning to Parliament and repeal it. I perhaps suspect the question is more intended to ask whether this act can be challenged legally. And my view is it can be challenged in part and it can be challenged in whole. As I said before, nobody wants a country where the government does not have some authority to ensure the safety and health of all citizens. So nobody here that I've heard tonight is advocating for a no-bill situation. I think we are saying let's have consultation so that the bill that comes out does the things the government wants it to do without infringing the rights unnecessarily of citizens. But yes, the bill can be challenged. In fact, the bill can be challenged even from the premise of how it began, because the words of the President of the Senate, which are on the record now, as to how the two new independents appointed temporary senators flies in the face of the facts. Because the way a meeting is summoned under the Senate rules, he did not proceed in keeping with Standing Order 9.6 of the Senate Standing Orders. This order said that where a meeting of the Senate is suspended or adjourned for lack of a quorum, and if a date for the new sitting is not announced, it shall stand suspended for a minimum of 7 days. But it goes to say, if something happens that requires the president to resummon the Senate before the expiration of the 7 days, she can do that. But there's a big but. It says the president must do so by writing the clerk. That never happened. All that happened was the president instructed an email to be sent. An email. My understanding from Independent Senator Adrian Oji is that he received an email at 9 p.m. Thursday telling him there is a meeting at 10 a.m. the following day. Now, believe it or not, there are lots of people, when they get to their homes, they do not do any social media. They put away their phones, and I can tell you that the Labour Party senators were not aware of the email until about 9:30 a.m. the following day. So the President of the Senate breached the Senate rules The Governor General breached the Constitution, which clearly states that Section 28 4C that a temporary independent senator must be appointed in the same manner that they were appointed under Section 24C of the Constitution, which is following consultation with civil society. We have a situation as well where they are independent senators, but people are card-carrying members of the government. People are on TV with commentaries in favor of the government every night. People are employed. The Constitution expressly forbids anyone who is in a contract with the position of senator, far less independent senator. So that's me.
Thank you, Mr. Francis. And whilst you're here with us, maybe your final comments in 1 minute.
So my final comments will be less than a minute. It's simply to say thank you for having me on this panel. And I want to end as I began to say that this is not a panel seeking to prevent the government from effectively controlling COVID. We are simply saying there's a way to do it. A bill that suppresses people's rights like this, there ought to be widespread consultation. And in this instance, the call for consultation did not just emanate from a political party. There were a number of civil society groups, which called very influential groups, the SLMDA, the Bar Association, the Tourism Association, the Chamber of Commerce. It is not too late for the government to have that consultation and to return to Parliament to amend the bad sections of that bill, of that act.
Thank you very much, Mr. Francis. Dr. King.
I just want to take this time to tell everybody COVID-19, SARS-CoV-2, it's a serious condition, serious virus. I don't want you to panic though. We know how to handle this virus. We know what it does and what it doesn't do. We know who is really most vulnerable to it, our elderly, and especially our elderly with comorbid conditions. So what I want us to do is don't be fearful of this virus. Don't allow fear to rule your life. Just be careful. Make sure you follow the basic rules of masking and hand sanitizing and distancing. And by the way, the mask is when 6 feet or more. You don't really need a mask if you're 6 feet or more away from somebody, or if you're on your own, or if you're in your own vehicle, as we know. It's only when you are within the 6 feet, you must have your mask. So people, let us just be careful and take that careful also to the next level, which we're trying to say tonight. Careful. Do not allow a government to take away your fundamental rights and freedoms. We had a hope and a dream of our ancestors, as they say, hopes and dreams of the slaves, we rise. Let us not disappoint the ancestors and give in to having our freedoms taken away from us yet again.
Thank you, Dr. King. Senator James.
Sorry, I was muted for a minute. First, I just want to say thank you so much again for having me. It's a pleasure. I know that my academic advisor, who is St. Lucian, who was a past minister, health minister, would be very proud that I accepted that invitation to be here tonight. But on a more serious side of the matter, I just want to just stress the point that we can have all of these public discussions, we can have all of these panel discussions, but the action, where do we go from here? That onus lies on the people to take charge and to ensure that you hold the people that you put into office accountable when they are not living up to the standards of the Constitution, the ultimate law. And I also want to stress the importance as well for persons, young people especially, we have life after COVID. There is life with COVID. It's a new normal. We have to get accustomed to it. May not be our type of Caribbean style of life, but we have to have a certain level of respect and to be our brother's keeper as well. Adhere to the protocols. Don't disobey, don't stray away from it. But at the same time, when issues like these arise, young people especially, because we would have to fight that journey, we would have to fight that battle going forward. And so we have to take that initiative and be engaged. The government has a deep responsibility to ensure that there is sufficient public consultation on laws and bills that would be passed that would affect the lives of persons, not financially, not only in a medical manner, but also psychologically and socially as well. And so with that, I just want to say thank you so much for having me. I have learned a lot from the well-educated panelists that we have here. And I would forever cherish this moment. So thank you so much, Lisa, and your team for having me, and have a good evening.
Thank you, Senator. Mr. Richelo?
Well, I'm very grateful for me being here with you today and I want to make the position very clear that at no point in time will I compromise my professional integrity not to speak my mind. And that is my position. And I think that this is the kind of situation which, to my mind, transcends any kind of boundaries, political or otherwise. And I think that it is important that this is a piece of legislation which requires serious revisiting. As a matter of fact, I am one of those persons who would advance the cause to ensure that, because this pandemic kills, it can be disastrous. I mean, we have to comply with all our protocols. I would encourage the St. Lucia as a whole to comply with whatever protocols are put in place. But at the same time, I do not think that I would be living up to my responsibility if I were to see a bill or an act of that nature remain on the books in St. Lucia. But I thank you, and I thank all the members of the panel for being here tonight. Although I know that I had late notice, but it was okay.
Thank you so very much, Mr. Richelo and Mr. Casimir.
Okay, let me just thank, on behalf of the people of Grosley and of course all of St. Lucia and indeed the region, we have persons locked on from all over the world. I want to say thank you to our panelists. We really did put together a good bunch of individuals that are independent thinkers, like Mr. Richelo, of course, Dr. King, and we just really had a really good discussion. Of course, special thanks to Miss James from Grenada, bringing that perspective over there. I think that was very important for our young people to listen and to hear, and of course, all of St. Lucia to understand what it means for collective decision making as a nation. Thanks to UTV for coming on board with this stream, and I think we really needed this. I think most persons, from the messages that I'm getting, they enjoyed our discussion tonight. A special thank you to the campaign team who are working feverishly to ensure that St. Lucia, Grosley and St. Lucia really understands what's going on in our nation. Special thank you to Armstrong Alexis, who's overseas and working extremely hard to get this thing done. And of course, Rustin Taylor and the rest of the team. Thank you, Lisa, for doing an excellent job. I want to say good night to Tekla de Tilvel, who's also overseas in Canada, participating in our discourse online, and all individuals who participated tonight. And I've been seeing a lot of requests to continue having these sort of forums, and I could see that we are willing and able to execute these sort of forums in the near future. Thank you, guys.
Thank you.
Thank you so very much, Kenson. And St. Lucia, we thank you so much for tuning in with us. We did invite experts in the various areas to present this information to you. And we ask you to please stay tuned to the Facebook page, Baby 4 Grosley. That's Baby number 4 Grosley. There will be more sessions like this. Do stay safe and have a good night, everybody.
If you haven't checked out Ram J's Auto Parts yet, what are you waiting for? We stock a wide assortment of older and newer model popular car and SUV parts. Suzuki, Toyota, Mitsubishi, Honda, Nissan, Mini Cooper,